All right, welcome back to the program. Thank you most kindly for staying with us. You're still watching Daybreak on Trust TV. Now, let's head over to Kano now to discuss what has been a very interesting drama that has continued to unfold with so many twists and turns, presenting Nigerians with quite the conundrum, looking at the battle for the emirate position of the Emir of Kano. And we're just going to segue right into it because since the State Assembly's repealing of that Emirate Council law, amending it, effectively restoring Sanusi Lamido Sanusi II as the 16th Emir of Kano State, we've seen so many developments that leave much to be desired. The return of Aminu Bado Bayero and his stay at a palace in Nasarawa, also part of Kano, and Sanusi Lamido Sanusi in the main palace of the emir. The back and forth, the legal cases, that injunction that stops the reinstatement of Sanusi Lamido Sanusi, and another one that came in just 24 hours ago, further adding to the complexity of the issues by stating that, Aminu Adubayaro should stop parading himself as the Emir of Kano, and also asking the police to vacate all of the other emirs alongside Aminu Adubayaro from the palace, from the State High Court, has further, compounded this already complicated situation. So let's now speak to our guest who is going to provide us with legal perspective to this development. He's Bashir Yusuf Mohammed. He's a legal practitioner, also based in Kano. Good morning to you, Bashir. Thank you so much for joining us, barrister. Appreciate you for taking the time.
Please, thank you for having me.
Right. Okay. Let me get your legal perspective on this conundrum. A federal high court has stopped the reinstatement of Sanusi Lamido Sanusi, but to add to it, a state high court has issued yet another order, or an order that contradicts that order of the Federal High Court, calling for the removal of Aminu Adubayaro as Emir of Kano, stopping him from parading himself as Emir, as well as calling on the police to vacate him from the Nasarawa Palace. What is your understanding of this legal complexity?
If you look at the two orders, for me, there was no any conflicting orders as far as the two orders are concerned. The first order allegedly made by the Federal High Court, Kano, was made by way of enforcement of fundamental right of someone called Aminu Babadang Akundi. And then if you look at the parties in this case that were given order yesterday by the High Court of Kano, the parties, Kano State Attorney General and the Dethroned Emirs of Kano. So, and then the matter was filed by way of originating summons, which is within the powers of the state higher courts to determine. So for me, there was no any conflicting order as far as the two orders are concerned. And then if you look at the first order first and read it well, the order was seeking the stoppage of the implementation of the law passed by the State House of Assembly. That was the, if you look at the main order, that was what was provided in the order. And in this main order, and the second order that was given in by the State House of Assembly, High Court of Kano, the order specifically made mention that the dethroned emirs should stop parading themselves as emirs of Kano and for them to vacate the house, more specifically the first respondent in the case, the house of the emir in Nasarawa, who is along State Road. So there is no any conflicting order as far as I'm concerned. And then even if there was two conflicting orders. The law is settled. It is clear by the Court of Appeal decision in Central Bank of Nigeria against Daladi that the earlier in time should prevail. So there was no conflicting order because there were two concurrent courts. The latter order should prevail. That was the law. So there was no any conflicting order. It's just for the authority concerned to comply with the later order as far as the law is concerned.
Okay, so based on precedent, right? One order came before the other. Doesn't it make sense? Or at least tell us the procedure now, because one order came in almost a week before the other one came in. Logically, to the average Nigerian, the thinking is, let's first of all address that order before we can move right to the next one. Or is there a jurisdictional argument that can be made here about which court has jurisdiction over this particular matter?
That is another angle of the argument. You see, it is clear that the Federal Higher Court has no jurisdiction on issue that has to do with the emirate issue at all. In fact, the Supreme Court, as all at the Constitution of the Federal Republic of Nigeria, pronounce a very clear decision in Tukur against Gongola State. That look, the Federal Higher Court has no jurisdiction on issue of emirate at all. In fact, if you look at read at that case, it's at the same scenario at this case that is happening in Kano. They then the Dethroned Emir went to the court challenging the decision of the House of Assembly of the then Gongola State that his enforcement or his fundamental right has been breached. And then the court of Supreme Court finally said that no, the Federal Higher Court lacks the requisite jurisdiction to even assume jurisdiction to entertain it because it is a chieftaincy affairs, which is clearly within the powers of the State High Court. That is one angle. And then what I'm trying to tell you is that if you look at the two orders, parties are different, because when you say that there is a conflicting orders, the first thing is for you to compare the two orders and see whether the parties are the same, the subject matter are the same or not. If you look at the two orders and compare them, you will see that the two matters are entirely different, and the later one is within the powers of the State Higher Court, which was rightly granted by the State High Court. And if you look at the first order given by the Federal High Court, even the judge himself in the order agreed that he doesn't have the jurisdiction to entertain the matter, because he made an order for the parties in the matter to come and address him because of the apparent, if I use the word that he used, apparent jurisdictional issues that were in the process filed before him. Now the issue is that, as far as the first order is concerned, when you look at it back clearly and do justice to the entire issue, you will understand that the State House of Assembly, under the powers given to it by the Constitution, specifically Section 4, Sub 6, 7A and B, passed a law that repealed the 2019 Emirate Law of Kano State. And you could remember vividly that they have made it clear to the world that we are going to amend this provision. This provision went for hearing at the house, at the pillow house of the House of Assembly. It passed first reading, second reading, and third reading. Nobody challenged the action of the House of Assembly at that stage. If you could remember again, they have quickly take the law to the governor of Kano State for assent, based on the power given to him by the Constitution. Again, Section 5 of the Constitution give the governor to assent the law, and immediately if he assent that law, it became the law, which he has done. In fact, if you could remember, it is after all these steps has been taken, the announcement of the Sunusi has been made. In the night thereafter, then an announcement was made via social media that there was an order restraining the House of Assembly and the governor from implementing the law, which has already been implemented.
Right.
It is a record. Everybody is clear on that. So now what I'm trying to say is that that order itself is just an academic exercise, because the action which the order seeks to stop has already been implemented.
Yeah.
In law, you cannot stop an action that has already been done by any arms of government.
Yeah, okay.
This is the position.
Yeah. So, Barrister, just on that point, I mean, the courts are there to provide interpretation and also to provide justice, I believe, which is the main idea behind our judiciary as a system. They can correct a wrong if at all a wrong was done, despite all of these pronouncements. That's why people can, be declared winners today of an election, and tomorrow the court says, listen, actually you didn't win, despite the fact that INES pronounced you, and then a reversal is done. And we've had several other civil and other cases that end up in that particular manner. But to stress the point about the actions of the State Assembly itself, there's some on the other side who argue that the State Assembly was not above board on the processes and the procedures, because the first and second hearing and the final hearing itself were conducted in less than 3 days, looking at how controversial the issues were. And one key component that is also constitutionally recognized that the State Assembly did not uphold was public hearing. There was no public hearing when they repealed and passed this new law and took it to the governor rather hurriedly for him to assent to. So that in itself is a loophole that needs to be addressed, isn't it? Because the Federal High Court order was also an effort to address that particular irregularity, that there was no public hearing leading up to the formation of that amendment to the Emirate Council law in Kano.
Well, let me correct the impression that the House of Assembly is governed by the rules of the House. They have a standard rules that guides the activities of the sittings of the House. It is not mandatory for the House of Assembly, if you look at the rules of the House of Assembly of Kano State on amendment of laws, to call public hearing. Mind you, they are not making a new law. They are amending the law. So the public hearing will come off when there was the need of creating another law for the benefit of the state, for the benefit of the people. In that regard, the position of the people need to be known. But in this regard, the motion was passed with an effort to amend the law, and all the members in the House of Assembly, including the members of the different political parties, their presence are there, and they lend their agreement that yes, there is need to amend this law. If you could remember vividly, the minority leader of the House made it clear that yes, they were in agreement for the law to be amended, but they were only against the deletement of the 5 new emirate created by the law. That is what he said. So what I'm trying to tell you is that the House of Assembly have acted in accordance with the constitutional power given to them and in accordance with the rules of the House of Assembly of the Kano States.
Right.
That
Okay.
impression given by some other people is misleading. And
Okay.
then let me tell you again that that order does not, if you look at it, is not intended to check the access of the House of Assembly at all. If you look at the process, I read the originating motion filed by the applicant in that case. He was saying that his fundamental rights were infringed, but there was nowhere in that process where he made mention that the House of Assembly did not follow the procedure. Nowhere, I tell you.
Okay.
I read it very well.
Right.
So it is that is had nothing to do with the procedure followed by the House of Assembly. And in fact, that is why this second case that filed by the state government, by the Attorney General of the Kano State and others, is seeking the court of the competent jurisdiction, that is the state higher court, to look at the law and determine whether all the procedures has followed. That is what is before the court.
Okay. So,
I have read all the two processes.
Yeah.
So what I'm trying to tell you, there is no any lacuna from the part of the House of Assembly.
Right.
There was no any lacuna from the part of the executive arm, such as the governor of the state, because all of them, they have followed the procedure. And all these procedures that they have followed are backed up by the constitutional provision. It is their constitutional power which they have, which they have exercised.
Yeah, Barrister, let's talk about the nature of this litigations. They are all ex parte injunctions, aren't they? The first one and the second one. So it means that the other parties were not heard before the court gave that order. And you have two orders that support two different sides of the argument. Because in the first order, if you're on the side of on the camp of the Aminu Ado Bayeros and the other emirs that were deposed, you would say, listen, there is a valid court order that stops the reinstatement of Sanusi Lamido Sanusi as emir of Kano, which the police also says it is going to uphold. We've seen that press conference from the police commissioner in Kano. And if you're on the other side, of the government side, on the Sanusi side, you would say, oh, we have a court order that also allows for Sanusi Lamido Sanusi to be recognized as emir of Kano, while also stressing the point that Aminu Ado Bayero, for instance, should stop parading himself alongside the other emirs as emirs in Kano State. How do you juxtapose both? Because legally, those court orders are valid, aren't they? I mean, one doesn't trump the other until the cases are seen to a logical conclusion. So how do both parties address each of those orders that seem to, go against them?
That is why I quickly tell you the decision of the Court of Appeal in Central Bank against something Yusuf Dalami. The Court of Appeal clearly, when fronted with a situation like this, made it clear that even where there was a valid orders of the two competent court of jurisdiction, the latter in time should prevail. Did you get the point now? What the Court of Appeal says is the position of the law.
Barrister, just to be clear, just to be clear, Barrister, how you vacate a federal high court order because there is another court order from the state high court, and you're saying the state high court overrules that of the federal high court? Is that what you're saying?
Of course, yes. In fact, what I'm trying to tell you is that if you look at the two orders first, you must understand that there are two different orders. The orders are not directed at the same, to aim the same achievement. The first order, if you read it well, is intended to stop the implementation of the new law created by the House of Assembly. You read it very well, you will see. That order is intended to stop the implementation. That implementation of the order has already been done before the order was granted. Do you get the point? And then this second order is trying to stop the dethroned emirs, which the law has already been recognized as dethroned emirs, to stop parading themselves as emirs of Kano. There are two differences.
Yeah.
So they are not in any way conflicted. Do you get my point? And then even if they are the same, they are aiming at the same, the Court of Appeal has made it clear. It's very, very clear that the later in time, it is not an equitable orders. They are all laws, because when you make an order, it is bind upon the parties.
Okay.
In our laws, it is only when there are two equal equities, then the first in time should prevail. That is some lawyers what they were saying. But this is not an equitable interest.
Okay.
It is an order of the court, and the Court of Appeal made it clear that the later in time should prevail. Let me give you an example, for instance.
Very briefly, Barrister, because we have to go. Very briefly. Go ahead.
The Court of if this in this 20.
Hello, Barrister. I think we've lost our connection to Barrister Mohammed Bashir. They're providing us with some legal context to the ongoing Kano Emirate battle, or saga as the case may be, over the throne of the Emir of Kano. And of course, if you're following these developments, there are so many twists and turns. And I must say, despite all the explanations from the legal experts, the more you look, the less you see as far as an understanding of what will make sense to a lot of Nigerians. But I must say that the next coming days or weeks perhaps will provide us with some clarity as the legal battle continues.